hello and welcome. You're with the news today, your primetime destination. News, newsmakers, talking points. The big talking point is coming around the Aam Aadmi Party leader Arvind Kejriwal, who will remain right through this weekend in ED custody. We'll be joined tonight, though, by a special guest. Joining me live will be Abhishek Manu Singhvi, the lawyer of Arvind Kejriwal. What is the case that he has in that big story? Also, it is a big debate tonight. India's top judiciary is caught in a political crossfire. Prime Minister Modi, Mallikarjun Kharge are weighing in. Is the judiciary truly independent? We're going to raise that with former Supreme Court Bar Association heads. But first, as always, it's time for the 9 headlines at 9 tonight. No relief for Arvind Kejriwal. The Delhi Chief Minister's ED custody is extended until April 1st. Kejriwal defends himself in court, challenges the ED to prove a money trail, says approver bought bail with electoral bond donation to the BJP. After the United States reiterates its demand for a fair probe against Arvind Kejriwal, India calls US remarks unwarranted, says interference in legal and electoral processes is unacceptable. India's legal fraternity split wide open. 600 lawyers write to the Chief Justice of India claiming attempts to undermine judicial integrity. Prime Minister Modi says courts are being bullied. Kharge hits back, says BJP politicizing the judiciary. Clean chit for former Union Minister Praful Patel. CBI closes 2017 corruption case lodged against the NCP Ajit Pawar faction leader. Aam Aadmi Party and the opposition cries foul, says central agencies closing cases if leaders join BJP. Maharashtra alliances, Mahayuti and the Mahavikas Aghadi are hit by seat-sharing troubles. Aghadi camp at loggerheads over Mumbai seats. Mahayuti also split over the Nashik contest. Bollywood actor Govinda enters politics again. The actor joins the Shiv Sena Shinde faction. Actor likely to be fielded from the Mumbai Northwest seat against Uddhav Sena's Amol Kirtikar. More trouble for Congress Neta Supriya Shine. Delhi police to probe her sexist post on Kangana Ranaut. Delhi ALG seeks detailed report on who put up the post from Shrine's account. A historic first for Saudi Arabia. The Gulf Kingdom will make its debut in the Miss Universe pageant for the first time. Rumi Al Qatani will represent Saudi Arabia. But our top story today, there has been no relief for the Delhi Chief Minister and Aam Aadmi Party leader Arvind Kejriwal from the courts today. The Delhi Chief Minister was remanded to 4-day more ED custody until the 1st of April. But Kejriwal came out fighting today, defending himself personally in court. He questioned the enforcement watchdog, challenged it to prove where the money trail was. The Delhi Chief Minister also raked up an approver's electoral bond donation to the BJP, claiming that there was a direct link between the approval and the money that had gone into the BJP's coffers. All of that is leading to plenty of political rumble. That is our top story today as we look at what happened in the court today.
A day in court. The Chief Minister of Delhi presented his case in person while agreeing to the Enforcement Directorate's request for remand. The CM aimed to mount a strong defense, accusing the investigating agency of unjustly targeting him without solid evidence and trying to undermine his Aam Aadmi Party. He labelled the liquor policy case as a politically motivated scheme.
आपके सीएम को बहुत तंग किया जा रहा है, बहुत परेशान किया जा रहा है, जनता जवाब दे।
The prosecution dismissed the arrested leader's allegations, requesting his custody to question him alongside other suspects in the Delhi liquor policy case. The PMLA court granted the ED's request, extending his custody by 4 days.
जो उनकी एप्लीकेशन लगी थी पुलिस रिमांड के लिए, उसमें जो ग्राउंड्स लिखे थे वो लीगली बिल्कुल सस्टेनेबल नहीं थे ग्राउंड। केजरीवाल जी ने रिक्वेस्ट की कोर्ट को कि मैं व्यक्तिगत रूप से कुछ कहना चाहता हूं, जो कोर्ट ने अलाउ किया और उन्होंने बताया डिटेल में कि मेरे खिलाफ क्या एविडेंस है, और कोई एविडेंस नहीं है, एक गवाह का बयान है या जैसे भी है। उसके बाद आखिर में उन्होंने कहा कि मैं पुलिस रिमांड को एज सच अपोज नहीं करता हूं, और जितना भी आप ये चाहें मेरे को कस्टडी में रख सकते हैं, मैं पूरा कोऑपरेट करूंगा।
Meanwhile, the Delhi High Court dismissed a PIL seeking Kejriwal's removal as Delhi Chief Minister following his arrest.
इस निर्णय पे कोर्ट कैसे पहुंचेगा कि अगर 3 स्टेटमेंट सेक्शन 50 में ईडी ने एक ही आदमी से ली है, वो अलग अलग हैं, तो एक ईडी को उठा ले उस स्टेटमेंट को और वो कोर्ट में दे दे कि साहब ये स्टेटमेंट सही है क्योंकि ये अरविंद केजरीवाल के खिलाफ है, ये 2 स्टेटमेंट अरविंद जी के साथ है इसलिए ये खारिज है। इसकी जांच कोर्ट कब करेगा, कैसे करेगा?
ये वही घिसी पिटी बातें, ये वही पुरानी बातें, उसी को एक प्रकार से रिपीट किया गया, परंतु राजनीति का अखाड़ा बनाकर कोर्ट को। इस प्रकार से भी कहा जा सकता है कि ये जो कोर्ट में हुआ वो, क्योंकि उनको यही फ्रेज समझ में आएगा, ओल्ड वाइन इन न्यू बॉटल प्रस्तुत करने का काम।
The bench refrained from commenting on the merits of the issue, which it noted were beyond the scope of judicial interference. With Munish Pandey and Srishti Ojha in Delhi, Bureau Report, India Today.
So let's turn to my first newsmaker tonight. Dr. Abhishek Manu Singhvi has been fighting for Arvind Kejriwal in the Delhi High Court. What case really does he have? Appreciate your joining us there, Dr. Singhvi. I want to understand from you, Dr. Singhvi, you've been an eminent parliamentarian for years. You're now joining me in your capacity as a lawyer. When I look at your arguments that you made in the Arvind Kejriwal case so far, the principal argument seems to be that you're questioning the timing of it. You're not necessarily questioning the specific facts of the alleged Delhi liquor scam, but you seem to be questioning the fact that the Enforcement Directorate has arrested Arvind Kejriwal just before the general elections, that this is timed with the electoral cycle, and that's the primary reason you seem to be calling the arrest illegal. Am I correct there?
Rajdeep, I'm sorry to say this is a disservice to both Kejriwal, to me, and shows the fact that you and your reporters have not heard the arguments. The arguments are now verbatim shown. Unfortunately, the High Court doesn't do live streaming, so you can't see the link subsequently after the arguments are over. I spent exactly about 45 minutes to 50 minutes arguing. 1 out of 10 arguments of mine, I repeat, 1 out of 10 were about the timing. It was, to just recall and recount without being technical, about basic structure, level playing field. It was about a case of August 2022, which betrays a complete lack of necessity to arrest in March 24, a case which started then. The third and fourth arguments were about the fact that the material on record shows that nothing which can be done without arrest has happened, necessitating taking him into custody. He's available for everything. 1.5 years have passed. There is no need to arrest. I've cited case law. The most important argument which you missed out, Rajdeep, in that, and that took almost 20 minutes. It's a very interesting, fascinating argument. I took 4 star witnesses. The entire case of the ED is based on 4 names. Bucci, I will not necessarily to go into details. Bucci Babu, one Reddy father, one Magunta Reddy father, Raghav Reddy his son, and Arvind, and one more chap.
Sarath Reddy.
Now in each of those, I showed a clear pattern demonstrated with dates. A recurring pattern in every case, but in this case clearly established. 7 steps. Step 1. You, Magunta, or Bucci, or Raghav Reddy give 1, 2, 3 statements, nothing touching about Kejriwal. Not a word. So they are called exculpatory statements. Step 2, and I demonstrated this for each of them. Step 2, you are arrested after many months of that statement. Step 3, they are kept in custody, obviously harassed, maybe pressured, etc. Step 4, they are granted bail by the ED recording through the law officer, the ASG, that we do not object to bail. in 2 cases because of inverted commas, close, unclose, back pain. So I told the court, I said, I wish everybody in this country got PMLA bail on back pain. Step 5, you come out and you sing a song like a canary in your 5th statement, 4th statement, 3rd statement about Kejriwal. And step 6, immediately thereafter, you are granted pardon and given approval status. All of them are either approver pardon or co-accused status people. I cited case law, and to quote you 2 felicitous lines from memory of the case law of the Supreme Court. The Supreme Court has said repeatedly, times without number, a co-accused and an approver is a most unworthy friend, if at all called a friend. His credibility is 0 because he has bargained for his freedom. So the principle of law is that if you rely only, I repeat, only on co-accused and approver persons, you must have corroborative evidence. Without independent corroboration to which this evidence can be supported, you cannot. And the entire ED case is based on, bereft of a word of corroborative, these 3 or 4 people with this sequence of events, all of them get bail or get pardoned.
No, but Dr. Singhvi, I listened to you patiently there because I wanted you to make your opening submissions uninterrupted. But the fact is, Dr. Singhvi, and the Enforcement Directorate has argued this in the lower court as well today, claiming that they have established a money trail between the so-called South group of the distillers you referred to, between them in Hyderabad, between the Aam Aadmi Party in leadership here in Delhi, and the monies that were allegedly paid in Goa and Punjab in cash amounting to 100 crores for the election campaign. This is what the claim is. This is the claim that the ED says they've made in court today, that they have a money trail which they are establishing, which does not just rely on so-called approvers and co-witnesses, and they claim that they will show an entire money trail between the South group, AAP and payments made in Goa once those Goa politicians are also now brought for ED interrogation.
Now, very good that you said so. So we've got 4 star witness statements out of the way. That's the entire case. Bereft of that, the case falls. Now let us turn to Rajdeep's second formulation. Did you notice, Rajdeep, in your formulation just now, you are talking of the future? We will show, we will demonstrate, we will establish. Tomorrow the sky may fall on our heads. From August 22, this case started, sir. Have they actually, remember, you are now talking of today's remand. I am talking of the yesterday's case I argued. Now today's remand, they are saying we will establish from August 22 to, as we talk, March 23. Kindly tell me, where is this elusive money trail? Is the ED keeping it in its pocket? And would they keep it in the pocket of the money trail? Your own formulation says we will do. Next point, very important, you don't know this. Yesterday, I read Manish Sisodia, para 15 of the Supreme Court judgment. Please mark my words, Supreme Court judgment. More than 2 months, 3 months old. Para 15 for the same liquor scam, for the same money trail, for the same 45 crores alleged to have reached Goa elections. The figure is quantified. Has given a finding, quote unquote, para 15. Prima facie, we find neither in law nor in fact this allegation of money trail of 45 crores to Goa having been made out. There's no separate trailer, this is the one. Now, third, what is much worse is this is a judgment in Manish Sisodia. It is a statement today in the PMLA where they are saying we will do in the future, we will do this, that and the other. As of now, there is not a word. They filed a 20-page grounds of arrest. 20 pages where these statements are shown. Not a word about how Kejriwal received, Kejriwal used, Kejriwal projected, Kejriwal converted, Kejriwal used. Nothing.
You know, Dr. Singhvi, the 2 points that you make now, let's look at them closely again. You mentioned Manish Sisodia's case. Manish Sisodia has repeatedly applied for bail right up to the Supreme Court. It's been denied. Number 2, as you well know, the Prevention of Money Laundering Act, PMLA, the grounds for arrest can be fairly wide as to what is a predicated offense. The grounds for denial of bail are also very difficult. And the virtual mention of the words proceeds of crime or POC, the whole concept is so wide that the ED can claim that Arvind Kejriwal is the beneficiary of proceeds of crime involving this South cartel. And until he is fully interrogated, he cannot be given bail because in their words, he is the principal mastermind. I'm using that word again, the principal mastermind of this case.
Rajdeep, let us get our facts. I'm very sorry, with great respect, you're wrong on all three counts, completely. The Manish Sisodia para 15 is cited by me because from para 1 to the penultimate para, every ground argued by the ASG, by the prosecution, is rejected. I repeat, rejected in my favor. Manish Sisodia is denied bail of the last paragraph on a different ground, not in the para I just read. The money trail you're talking about regarding Goa is in para 15, which is held in my favor. So that's highly relevant. The rejection is ultimately on a totally different figure, different point. Number two, adjectives don't make cases. Mastermind, I can call you kingpin, I can call you Dawood Ibrahim. Does that justify that you can keep me behind bars? These are adjectives. We're talking facts here. Number three, POC, which is a well-known term of art in PMLA, which is proceeds of crime, must involve concreteness. So there are 6 words used in section 3. Use, project, convert, etc. or receive. But none of this is shown. This was not even able to be shown in Manish Sisodia, who's one closer, allegedly. Kejriwal is one far removed. So you actually, and how do I argue this, Rajdeep? Your own grounds of arrest till yesterday are only these 4 chaps, these 4 star witnesses. Today you say we will do something in the future. You can't keep a man behind bars for weeks as sitting chief minister, a man with no evidence on the ground that we will come out with the rainbow and the sky after 2 weeks.
No, it's not just the 4 witnesses. You know, the fact is the ED claims Dr. Singhvi, they are going to confront Mr. Kejriwal with specific individuals now, including those who've received the monies in Goa, including those who are behind bars at the moment, and thereby establish this entire conspiracy, as they are calling it.
Confrontation is a different process that is happening after the arrest. Please remember, our petition is challenging the grounds of arrest. At the time when I arrest you, Rajdeep, God forbid, at that time, I need to have material in my hand justifying the necessity to arrest. That is given in 20 pages of grounds of arrest, saying I am arresting you, Rajdeep Sardesai, for the following 20 grounds, or pages rather. In that, the only evidence, I repeat, the only evidence is these 4 people which I have shown. Don't say anything, then get bail, then get approver, and then sing like a canary.
Well, Kejriwal goes even a step further and says then they pay bonds, then they buy bonds which benefit the BJP. I won't go into that debate at the moment, but can I ask you in conclusion, given the fact that the accused in the case in the past have not got bail for months on end, given the difficulties under PMLA to get bail, will you accept, Dr. Singhvi, that under Section 45, it will be very difficult to get bail in PMLA where the accused has to prove his non-guilty, that he is innocent? Do you therefore see your client, sir, spending an extended period behind bars?
Now, I'll answer your question immediately with 2 points. First, you repeated it twice, so let me clarify. You are right. 45 is a difficult provision to get bail, is extra negative provision. But what you forget is that Vijay Madan Lal Chaudhary onwards, the Supreme Court has said repeatedly, correspondingly, because 45 is difficult and stringent, 19 grounds of arrest were made equally stringent. So the reason I cannot easily arrest Rajdeep is because counterbalancing 45, I have put the grounds of arrest on a high threshold. Because I know that Rajdeep, once arrested, cannot get bail easily under 45. Therefore, the courts say that at the point of arrest, you must have reason to believe based upon material in your possession. Those are the exact words of 19. Now, the material in your possession on which you formed the opinion of reason to believe is only these 4 witnesses. Now what you will do by confronting Singhvi with Rajdeep, is something when you're already in custody. We are talking of the threshold when you arrested me. There could not have been confrontation at that time. Now, the confrontation what we get is something irrelevant to the grounds of arrest. We are not here on bail. We're not arguing bail. We have filed a petition challenging the grounds of arrest under Section 19, which means that the arrest per se is void. The threshold, the foundation, the initial step is bad.
You're calling the arrest per se illegal, but you also went ahead and made what I found an interesting argument in court, claiming that the arrest violated the basic structure. You're claiming that of the Constitution, you're claiming that Arvind Kejriwal's arrest is a violation of the basic structure of the Constitution, claiming that a level playing field in politics, it appears, according to you, is not being provided to Mr. Kejriwal, and hence Mr. Kejriwal should be given bail because elections are coming and his arrest should be deemed illegal.
Most of what you said is correct, except you use one wrong word. Politics. Let me explain. It's a very short. First of all, remember the great power, the pride of India and the envy of the world. The basic structure in one sentence says, if a constitutional amendment violates basic structure, the constitutional amendment is unconstitutional. Look at that power. Now, the way I have framed it is this. A, from Indira Nehru Gandhi versus Raj Narayan, a judgment of 1975, the Supreme Court has said that democracy and free and fair elections are a part of basic structure. That's like 40 years ago. Now, democracy and free and fair elections in turn depend only upon a level playing field. A level playing field is completely skewed, made uneven, non-level by a simple thing. A, by disabling political parties through their leaders being incarcerated from fighting elections at all. There can't be an effective election fight if you are in jail, right on the cusp of the election. For an August 22 case, surely you can arrest me in June if you want to arrest me. Can this man run away? You arrest. That's why it's not a timing argument merely. The timing argument relates to a basic structure argument.
So that
what is the imminence, urgency, and necessity to arrest on an August 22 registered matter? The first summons to Kejriwal came in October 23, 23.
Which he did not
6 months
attend.
later, after the MCC comes into force, the Model Code of Conduct, you go and arrest him.
Because he did
Second argument is that you also then try, not that it will happen, try and disintegrate the party because the leader is gone. It's headless in a de facto sense. So you are achieving multiple things with one attack.
Right.
You want to go into elections. It's like saying you go into a football match and you've either arrested the captain or taken the goalkeeper away, and you say let's go and play football now. That's a basic structure. That's a level playing field. That's a free and fair elections, and that's democracy. All of this goes straight into basic structure. What else?
Dr. Singhvi, that's an interesting but a contentious argument that you claim his arrest is a violation of the basic structure. I might point out that he avoided half a dozen summons from October. I will ask you, therefore, in conclusion, what do you expect will happen next? What is your next move? What's your next move?
Or Kejriwal or an accused or anyone for that matter, what does he expect? He only expects ultimately justice from the constitutional courts. That's the last resort. You cannot go and beg before Caesar if Caesar is the villain. You can only go to independent. Caesar's time did not have an independent system. We hope and wish and pray that those independent constitutional courts will come to our aid. Now, if they do, it's very good. If they don't, tough luck. But we have to bear it. But the point of the matter is, it is at such times that the entire constitutional fiber is tested.
Let me leave it there, Dr. Singhvi. You are, for some reason, and I can gather why, one of India's top lawyers. Therefore, I appreciate you coming here and giving us your viewpoint, battling for your star client. Abhishek Manu Singhvi giving us the Kejriwal argument in court. Now, we're talking about the Constitution, we're talking about courts. The big story is coming today in a way from the Supreme Court, because India's legal fraternity is split wide open on political lines. A group of 600 lawyers today, including the likes of Harish Salve, wrote a letter to the Chief Justice of India, D.Y. Chandrachud, claiming that a vested interest group is putting political pressure on the judiciary. Just hours later, the Prime Minister endorsed the letter, claiming it is Congress culture to bully courts. The Congress hit back, claiming it's the BJP which has gone ahead and politicized the judiciary. Is now even India's Supreme Court getting caught up in polarized politics? That's going to be my lead talking point. Take a look first at this report.
The judiciary is caught in political crossfire. Over 600 lawyers wrote a letter to Chief Justice of India, D.Y. Chandrachud, warning the Supreme Court against what they call pressure tactics by vested interest groups. The signatories to the letter include Harish Salve, Bar Council of India Chairman Manan Kumar Mishra, Supreme Court Bar Association President Adish Agarwala, Pinky Anand and Hitesh Jain. The letter claims the vested interest group was propagating false narratives about a golden era of the judiciary. They claim such an attempt discredits the current proceedings and undermines public confidence in the courts. The lawyers allege that this group selectively criticizes or praises the court orders based on their political agenda. The letter says it is troubling to see lawyers defend politicians by the day and try to influence judges through media at night. The group has concocted a theory of bench fixing, the letter claims. The letter ends by telling the Supreme Court that staying silent or doing nothing could give more power to those who mean to do harm.
जहां तक इस ज्ञापन का प्रश्न है, इनका अल्टीरियर मोटिव क्या है मुझे पता नहीं, लेकिन इस बात से मैं बिल्कुल सहमत हूं कि जुडिशरी की गरिमा को टार्निश किया जा रहा है. इसका रीजन है वर्तमान में जब हम परिस्थितियां देख रहे हैं पिछले 10-12 साल से, जुडिशरी को एक बहुत ही नॉर्मल चीज समझ रहे हैं. वो ये न्याय मंदिर पे जो डॉट लग रहे हैं, ये एक चिंता का विषय है. इसमें चाहे कोई भी पार्टियां हो, कोई पॉलिटिकल पर्सन हो, कोई भी पावरफुल पर्सन हो, मनीड मैन हो, इसको रोका जाना चाहिए और उस पर एक्शन लिया जाना चाहिए.
Prime Minister Narendra Modi seemed to endorse the lawyers when he posted on X, quoting their letter. Prime Minister said that it is a vintage Congress culture to browbeat and bully others. He also claimed that 5 decades ago itself, Congress had called for a committed judiciary. Congress shamelessly wants commitment from others for their selfish interests, but desists from any commitment towards the nation, he wrote.
जो लोग दबाव बनाते हैं न्यायपालिका पे, न्यायाधीशों पे आपत्तिजनक टिप्पणी करते हैं बिना प्रमाण के, ये चिंताजनक है और मैं समझता हूं ये चिट्ठी जो जन भावना है उसी को दर्शाती है.
The Congress accused the Prime Minister of brazenly orchestrating and coordinating an attack on the judiciary. The party added that no one should question the dignity of the Supreme Court.
न्यायपालिका को हम सबको सम्मान करना चाहिए और उस पर कोई सवाल इस तरह से नहीं कि उनकी नीयत पे कोई सवाल नहीं उठाना चाहिए.
The letter comes just days after the Supreme Court scrapped electoral bonds and directed the SBI and Election Commission to reveal details of donors and beneficiary parties. Bureau Report, India Today.
Very, very serious matter. The Supreme Court, is it being caught in a political crossfire now? Is it the electoral bond verdict that's behind this letter that has split the legal community? Who is putting pressure on the Supreme Court as the letter alleges? I'll be joined by two former presidents of the Supreme Court Bar Association, but my first guest is Hitesh Jain, advocate, signatory to the letter, also a member of the BJP. Appreciate your joining us, Mr. Jain. Can you tell us what prompted 600 of you to write this letter? Is it the electoral bonds verdict that went against the government in a way that has prompted you all to suddenly believe there's political pressure on the Supreme Court?
Rajdeep, I don't think electoral bond verdict has got anything to do with the letter, because after the electoral bond verdict came, we did not indulge in calling the Supreme Court. Neither the judges were criticized, neither the Supreme Court was criticized. On the contrary, there is a pattern that has emerged in the last 2 months, that whenever a Supreme Court gives a verdict, you start trying to call it an agenda. I will come to the point straight away. You remember just 2-3 days before, when Kavita's matter was being argued in the Supreme Court, and when the Supreme Court was reluctant to grant the relief, and the Supreme Court clearly told Mr. Sibal that you have to go to the lower court, it was Mr. Sibal who reminded the Supreme Court that this you will not be this period will not be treated as a golden period, and you have to pass the order. And if you don't pass the order, then they try to tell the Supreme Court and remind them about the legacy. Second, if you would have noticed, after Article 370, after Ram Mandir judgment, the kind of attack that was used against the judiciary and particularly against the Chief Justice. So after the electoral bond verdict, the Supreme Court was not attacked, but conveniently, whenever there are people who are involved in the corruption matters, there are politicians who accuse them for the corruption. They appear for them in the courts, and when they do not get the favorable relief, they start name-calling the judges. I will just finish in 30 seconds more. Recently, there has been a concentrated, and I will use the name very responsibly, there is a section of lawyers who have used the social media to basically criticize the judgments of Justice Bela Trivedi also, by straight away saying, oh, she is going to pass the orders in favor of the government. There is a pattern. We are not going to get the relief and all. See, Rajdeep, this is matter of concern when you start putting an aspersions on the judiciary, you start name-calling the judges, and it is the common man's belief in the judiciary that starts getting shaken up. That is the matter of concern.
Okay, but the fact is your letter has come within a week of the electoral bond verdict, which many believe has embarrassed the Modi government. So therefore, people are perhaps assuming that that this letter has been written because the electoral bond verdict has embarrassed the government. The point is your letter seems to suggest that Justice Chandrachud is going to be influenced by the surround sound, as will other judges. Is that what you are claiming? That judges of this country are so fallible that they will be influenced by what someone writes on social media about them?
Let me come to this point straight away. The letter expresses the confidence in the judges of the court and the Supreme Court, and it also tells the Supreme Court that we stand with the court. But the problem is the kind of smear and the whisper campaign that has been started to tarnish the reputation of the judicial institution, to tarnish the reputation of the judges, to tarnish the reputation of the courts, to tarnish the reputation of the lower court. That is a matter of concern. That is the most important issue. And why should, see, as a lawyers, we win some cases, we lose some cases. But then when we lose the cases, we start blaming the judiciary, we start blaming the institution, we start blaming the judges. That is a matter of concern.
No, but Hitesh, as you well know that Adesh Agarwala, the SCI, the Supreme Court Bar Association president, after the electoral bonds verdict said, I want a presidential reference. Questioning. You see, both sides question the judiciary when things don't go their way.
Rajdeep,
you see, the point is you are dragging the judges into your political battle. Why drag the judges into your political battle?
But Mr. Adesh Agarwal also never casted any aspersion on Supreme Court judges. There are some lawyers, they have gone to the extent of comparing that the Indian Supreme Court is akin to the judiciary in Pakistan and China because it just gives the judgment in favor of the government. What sort of criticism is this? I mean, I'm sure even you will agree. Can you compare our judiciary with what is happening in China and Pakistan? That is the interview that have been given. That is what is being fed to the young law students. That is what is being fed to the lawyers. That is what is being fed to the public at large. Is Supreme Court required to be subjected to such kind of comparison? Do we compare our Supreme Court to Supreme Courts of Pakistan and China?
Okay.
I mean, we can have the criticism of the judgment, but certainly you never compare the institution to the Supreme Courts of China and Pakistan, which happened 5 days before. This is all a matter of concern.
Okay. Hitesh Jain, for giving us the reasons why you've signed on to that letter. I appreciate you joining me. Let me widen this debate because this debate requires now some senior lawyers also to join us. Vikas Singh is former Additional Solicitor General and a former President of the Supreme Court Bar Association, as is Dushyant Dave, Senior Advocate, Supreme Court. Great to have two fine legal minds joining us on the show today. First to you, Mr. Dave, your first reactions to this letter. As you heard Hitesh Jain, the lawyers who've signed on are upset with the scurrilous remarks that are being made against judges. You, among others, have been at times accused of taking on some of the judgments of the higher judiciary. Okay, we'll try and get Mr. Dave in a moment. Vikas Singh, you want to respond to this letter which has been put out? What does it indicate? Is it that all is not well within the bar and the bar is being split politically now?
Well, Rajdeep, to start the answer, I would like to first of all comment that I am very happy to see Mr. Salve and some very good company of Mr. Harish Agarwal in the same letter. Now, as far as this judiciary attack on judiciary is concerned, there is a concern of the people of this country. And the concern is that if there is a special bench to be constituted every time when some politically sensitive case comes, and that special bench comprises of 3 presiding judges, so they leave their 3 different benches and come and sit together, then that's something which is, it raises an alarm. Why can't it go to a normal bench? Why can't a matter of this kind go to a regular bench?
No, are you suggesting you're making a serious charge. You're hinting somewhere there at bench fixing, which is one of the points which is made in this letter, that who are these lawyers when they don't get a verdict in their favor, say the bench is fixed?
So, Rajdeep, I'm not saying that, I'm saying it is a question of bench fixing, but it is definitely a matter of concern when a regular bench doesn't hear a matter and a special bench is constituted. That is number one. Number two, when you say that a person of, a political person like this, like Mr. Kejriwal or somebody has to be arrested, I am not getting into the merits of it. I'm sure there must be something very seriously wrong with what Mr. Kejriwal has done. I'm sure that he will have to face the trial and he will have to bear the brunt of it. But there is no necessity to arrest somebody, because if you read Article 20 of the Constitution, you can't be compelled to, implicate yourself in a crime. Now, when you say that he's evading answers, I mean, I have a right to keep silent. So when you say he's evading answers, if he feels that a particular answer is going to implicate him in a crime, he has a right to keep silent. So where is the question of keeping him in custody just because he is using his fundamental right of not responding at a time when he feels that there is an...
I'll come back to the Kejriwal case also, but I just want to widen this debate. And Dushyant Dave, since you have been among the lawyers who've spoken out vociferously at times against what you believe is a problematic higher judiciary, do you want to respond to this letter which says who are the lawyers who are speaking out in this manner? They are putting undue pressure on the judiciary by making these statements.
Well, I must say one thing, that the letter is an insult to the judges first and foremost. And because if the signatories of the letter suggest that, yes, the judges are going to be pressurized or are going to count down because of some, submissions made at the bar, which lawyers are entitled to make, then I think the signatories have done a great disservice to the institution by writing that letter. They are completely ignorant of law. Let me tell you one thing. I just heard Mr. Jain. Article 32 is a fundamental right, and a fundamental right to enforce fundamental rights. And right from 1950s, particularly in 1962, a judgment of the Constitution bench in Dariao versus Bihar, the Supreme Court said that it is our privilege and duty to entertain every petition when fundamental rights are complained of being violated. And we cannot relegate parties to High Court or other lower courts. Now, that's the law declared by the Supreme Court. That law has, stood for a long, long time. I have not seen a single judgment which has really upset that law on principle. And yet again and again, these judges, without understanding that these are serious cases of violations of fundamental right, not only of the individuals involved, but institution, of democracy is under challenge. I am not here to support corruption. If somebody is guilty of corruption, he must face the trial. No difficulty about it. We are talking about right to bail. Supreme Court has said consistently, jail is a rule, bail is an exception. Sir. Now, what is happening today, that, these matters are being dealt with, unfortunately, by only select few judges. And these judges are constantly sending these people to trial courts.
No, but by saying that, Mr. Dave, aren't you casting aspersion on the judges? By saying not that the matters are being sent to a particular judge and the judge is not granting bail, aren't you casting aspersions?
Rajdeep, I am not casting aspersion. I am stating a fact. If you see the record of the Supreme Court, it will tell you where these matters are being assigned and what is the outcome of these matters. And as against that, I can tell you one thing, that large number of other people are getting away with getting all kinds of reliefs.
Sir,
So,
the letter...
for example,
Sir, just a minute. Mr. Dave, the letter...
No, just a sec. This Mamata Banerjee's nephew, Abhishek Banerjee, the ED called him. And he ultimately came to Supreme Court. ED came, I think, or he came. Right. And before Supreme Court, ED makes a statement saying that, the elections are coming, therefore we will not call him now. We will call him after election. And Supreme Court bench presided by Justice Bela Trivedi herself says, yes, elections are taking place. Therefore, we adjourn the matter until such time we will not be called by the ED. Now, what do you make out of it? I mean, it's really, you have to...
Sir, as I said, somewhere... Sir, can I just, as we get your video back, can I just turn back to the letter? Sir, the letter, Vikas Singh, and I want both of you to answer this, says, tactics employed by the interest group involve selective criticism or praise of court decisions based on their political agenda, described as a my way or highway approach. Vikas Singh, you first, and then Dushyant Dave.
So, Rajdeep, when you say that lawyers or a particular client is asking for bench fixing, it's actually very unfair to say that, or very, very, uncharitable to the lawyers. What lawyers have always been demanding, and I support that demand, that this roster system came in 2018 when I was president for the first time. And that you remember that interview that happened by 4 judges, and they said that matters are being selectively marked to a particular judge. So as president of the bar, I made a demand that there should be a roster system where matters should go by randomly in that roster of, so whoever are handling a particular matter, it should go and there should be distributed in that order. But unfortunately, that has been completely done away with now. And now suddenly a particular matter goes to a particular specially constituted bench. I don't understand, if there is a roster system where there are judges to deal with a particular roster, why a special bench is constituted, disturbing 3 different
questions on Justice Chandrachud, and are you saying that because ultimately he's the master of the roster?
So it's for you to deduce what I'm saying, but as far as I'm concerned, I feel that a roster system, the integrity of the roster system is that any matter should go as per the roster, and that is what the lawyers have been demanding. Okay. So to say otherwise, that the lawyers are asking for bench fixing, is absolutely just the opposite of what they are demanding. They are saying that if there is a roster, let it go as per roster, rather than fixing a particular bench to hear a particular matter.
Okay.
Now, that is something which is completely against the very principle of roster system. That is what the bar has been saying. And to cast aspersions on the bar, I think, is completely uncharitable.
Can I therefore get you, Dushyant Dave, to respond to that critical point in the letter? Tactics employed by the interest group involve selective criticism or praise of court decisions based on their political agenda, described as a my way or highway approach. They seem to suggest that that there are elements within the bar who are trying to put political pressure, as I said, on judges when judgments don't go their way.
Well, first and foremost, let me tell the country that when I think Mr. Manmohan Singh, then Prime Minister, and Mr. Ghulam Wanwati, then Attorney General, were accused of having done something wrong in Colgate files, I was the one who went on television to say that both must be investigated and prosecuted. So I have nothing to do with Congress or BJP. I am here to stand for the Constitution and for my democracy, first and foremost. Secondly, I think this is an orchestrated letter. The way this letter is written, the way it is, publicized by media across the country, and then the Prime Minister himself tweets about the letter, shows that this letter is clearly orchestrated at the instance of the ruling BJP. And I'll tell you why. The BJP is having a free run since 2014 in the Supreme Court, with successive Chief Justices like Mishra, Kher, Gogoi, Bobde and Ramana really doing almost everything that the government wanted, be it in terms of judgments, be it in terms of appointments to Supreme Courts and High Courts. Now, for the first time, Chief Justice Chandrachud and his court is making a pushback against the executive. Chandigarh Mayor's appointment, for example. Now, this fact-check notification, then this, electoral bond judgment. These are the things which suddenly the government is finding very uncomfortable with. And that's the reason why the government is, through this letter, trying not to give message to the judges who did not give relief to Arvind Kejriwal or Kavita, but to the Chief Justice. So I think that this letter, unfortunately, is a very sad commentary on the part of these so-called prominent lawyers who have written this. Frankly, Mr. Jain should know what the law is about. I must say, one more thing. Under Bar Council's rules, the advocates under Rule 5 have to defend their clients fearlessly before the judges. And that part of fearlessness entitles you to tell the judge that you are making a mistake and that therefore history will tell you that you made a mistake. There's nothing wrong about what Sibal said that day. One more thing. There is a judgment by Justice Arun Mishra himself in 2019 where Justice Mishra discusses the role of the bar and says bar must be independent not only to protect the honest judges but also to call upon erring judges and call them names. He said that bar must expose them, bar must talk about them. So I don't think Mr. Jain and all these prominent signatories really are aware of what the law is. We are doing our duty. Under Article 51A, the duties that citizens must perform, one of them is that he must uphold the constitutional values. I am upholding my constitutional values as I look at it. I am not trying to demean any judge. I am not trying to disrespect any judge. But I am certainly entitled to show a mirror to the judges of the Supreme Court that you are not following your own law. And you are selectively following that law in respect of some while denying others relief. So that's something which I feel is not at all wrong. This letter, to my mind, is really to bring pressure on the Chief Justice and those good judges who are doing some extraordinary work in recent times.
You know, listening to both of you, it's been a pleasure, but you've again made an imputation somewhere that this letter has been written on the behest of the BJP, which
Absolutely.
Again, Mr. Dave, you're making that charge. Okay. As I said, therefore, the judiciary will find it, the bar is finding itself tangled in political battles. Quick 30 seconds, I must give Vikas Singh, who listened patiently. Is that a fear as a former president?
Before Vikas Singh comes in, I must say, and Vikas will agree with me, that the bar knows who these prominent lawyers are and what they stand for.
Okay.
So the whole legal world knows about it. Okay. We don't have to debate it on television.
Okay. It's a bit like people will say tomorrow, everyone in a newsroom knows who stands for what. That debate on another day. But 30 seconds, Vikas Singh, is this going to really split the bar wide open if it wasn't already?
So, as far as I'm concerned, Rajdeep, there is a bar which is an independent bar which has no concern with any political party. And I also am one of those who have actually no concern. I criticize the Congress also whenever I feel that they've done something wrong. So I feel that it is my duty as an advocate to be clear of what the Constitution stands for.
Right.
So the bar as a whole will always remain united. But yes, there are some sections of the bar who want to align with a particular political party. That by itself will not make, the bar in any manner divided.
Okay.
And the bar, according to me, the unified bar will always remain as a strong pillar of this institute.
Gentlemen, both of you have taken time off from your holiday break. I know lawyers are on holiday in this Easter week, so I appreciate Vikas Singh and Dushyant Dave. Pleasure listening to two fine legal minds on the show tonight. Thank you so much for joining me.
Thank you very much. Good night.
Okay, let's turn from there to give you a quick wrap of what else is happening in the 2024 election battle. Bollywood actor Govinda today joined the ruling Shiv Sena in Mumbai in the presence of Maharashtra Chief Minister Eknath Shinde. As per sources, Govinda is likely to now contest from the northwest Mumbai seat is what Govinda will be contesting from. With only days left for the Lok Sabha polls, the Aam Aadmi Party has alleged the BJP is allegedly orchestrating an Operation Lotus in Delhi and Punjab. Delhi Minister Saurabh Bhardwaj claiming AAP legislators are receiving calls to join the BJP. The Shinde Sena released its first list of Lok Sabha candidates. It's fielded Rahul Shewari, the sitting MP from Mumbai Southwest. Suspense still prevails though over several seats in Maharashtra. Mr. Siddaramaiah and DK Shivkumar put an end to a revolt over Karnataka's Kolar seat. Congress says peace meeting was successful. Ahead of Lok Sabha polls, the CBI has gone and given a clean chit to NCP's Praful Patel by closing a 2017 corruption case. The Congress says this is typical of the washing machine of the BJP. Let's turn to tonight's Get Real India story, which comes from Odisha. A 91-year-old woman from Kendrapada district will finally get her long-awaited family pension. The woman struggled for more than 40 years, that's right, 40 years, to finally get her pension disbursed. Take a look at tonight's Get Real India story.
Hara Sahu's 46 years of struggle have finally yielded results. The 91-year-old will soon be receiving family pension denied to her by endless red tape. The Odisha High Court on March 22nd set the Kendrapara District Collector a 1-month deadline to disburse her long-awaited pension.
डेट देला परे पेंशन आमे तो असुविधा थेलु डेट देला परे पेंशन में कागज पत्र ठीक ठाक करी दौड़ा दौड़ी कला परे भी किसी रिजल्ट आसी नथला तापरे केस पड़ी थला किंतु तापरे आमे धीरे धीरे केस लड़ू तो 22 वर्ष अधेलाड़ी आ रिजल्ट तो आज आसी आ.
Hara's husband, a school teacher in Kendrapara, died in 1977. Hara and her only son filed several applications with authorities to secure the family pension. In August 2023, the Kendrapara District Collector rejected her plea for family pension and other benefits, saying the scheme was introduced in 1980 to 81 while Hara's husband died in 1977. Hara moved to High Court in October last year. The court quashed the collector's order in November 2023 and directed the authorities to sanction the pension along with arrears. But Hara still did not receive any money.
केस बहुत यही करी बर्ताने माने हाई कोर्ट राय दी.
The court in its latest order has warned the administration any failure to meet the deadline will be seen as a deliberate violation of the order. With Ajay Kumar Nath in Kendrapara, Odisha, Bureau Report, India Today.
Imagine 40 years to get your pension. Let's turn to a nice fun story to end tonight. The character of Chacha Chaudhary is liked not only by children but also by adults. Now Chacha Chaudhary and Sabu will be teaching you how to vote. The Election Commission has taken the help of these cartoon characters to make children motivate their parents to vote. Take a look.
Chacha Chaudhary and Sabu are on election duty. The Election Commission is using the popular cartoon characters to spread awareness about voting among primary school children in Uttar Pradesh.
For example, 2 जनवरी को अगर आप हो रहे हैं 18 साल के तो आपको 1 साल वेट करना पड़ता था बिकॉज हमारी एलिजिबिलिटी डेट वाज 1 जनवरी जिसमें आपको माना जाता था कि अगर आप 18 साल के हो गए तो आप वोटर बन सकते हैं.
The EC has distributed a form to schools through the Education Department. The voting percentage in Uttar Pradesh in 2019 Lok Sabha election was 59%, while the national average was 67%, a gap of nearly 8%.
ये धन्यवाद सीओ यूपी की तरफ से है कि वो आभार व्यक्त कर रहे हैं कि आपने अपना ये संकल्प लिया है कि आप अपना एक तो वोटर जरूर बनेंगे, उसके बाद अपना वोट एक्सरसाइज करेंगे वोटिंग वाले दिन, जिससे कि आप अपने एक फ्यूचर और अपने डेमोक्रेसी को सिक्योर करने के लिए जो अपना स्टेप ले रहे हैं, जो मेहनत कर रहे हैं.
The EC is hopeful that Chacha Chaudhary, whose brain works faster than a computer, and Sabu, the Desi Superman, can convince the people of UP to exercise their right to vote. With Shilpi Sen, Bureau Report, India Today.
That's about all that we could pack in on the news today. Thanks for watching. Stay well, stay safe. Good night. Shubh Ratri. Jai Hind. Namaskar.